Once a contract has been created, whether you have entered that contract either in the form of an offerer or the acceptor, that doesn't make a difference. Both the parties, because in the process they have to provide consideration to each other, so there is an obligation to perform. So we can say that the creation of a contract creates obligation for both the parties, and therefore, once that obligation is fulfilled, then we should say that both the parties must have discharged their contract. So this discharge can be in various other modes also. So what we are discussing here are the various modes in which a contract is discharged, that denotes that the parties who are associated with the contract, whether as a offerer or acceptor, are shrugged off from their liability under the contract. So basically, this discharge of contract denotes the death, or we should say, the closing of the obligations of the parties concerned. And we will have these five primary ways where the contracts will be discharged and both parties will not have any liabilities in the future under the contract. So the first is the by the death of the promissory, that denotes that contract being primarily a contract of personal nature, that is the liability is personal of the party who is entering into the contract, and therefore one of the death of the promissory will render the contract invalid, and hence the other party will be discharged from such contract. Similarly, there is always a time limit that will be prescribed as per the contract. So you have to fulfill the obligations within that parameters of time. And sometimes no specific time limit is mentioned, then as per the industry standard, the customs will decide the normal period within which the contract needs to be completed. And once this time limit lapse, that is, the contract is not taken into force within that time limit, then by the lapse of the time, the parties will be discharged from such obligations. Or sometimes we can also say that there was a time limit to complete the contract, and one of the parties failed to complete the contract within that parameters. Then there can be a clause in the contract that once the time limit will elapse, then after a period of notice, the contract will be discharged, and there will not be any further liabilities of the other party on the same contract. So this lapse of time will also make an impact in discharging the liability of the parties concerned. Similarly, because contract is a civil contract where you will have financial liabilities. So for because if one of the parties fails to fulfill his obligation, then he's under an obligation to compensate for the loss of the other party, and therefore, if one of the parties has been declared as insolvent, then being insolvent, he is not able or he will not be able to fulfill any of the liabilities in the future. तो अगर पार्टी इंसॉल्वेंट हो गई तो अब वो किसी भी तरह के डैमेज को पे करने के लिए कैपेबल नहीं है. So the other party will not enter into any such contract because they believe that any default from such insolvent party will not cause any right to them, and therefore this declaration of legal insolvency of any of the parties discharges all the parties associated from such contract. So if you feel that first and three are more of personal causes which causes the discharges. Now if we go to the fourth part, that is the by agreement, and this justifies that because the creation of the contract was with mutual contract or mutual consent. तो कॉन्ट्रैक्ट आपने बनाया था म्यूचुअल कंसेंट से, and the same mutual consent can also cause the discharge from such contract. तो जिस म्यूचुअल कंसिडरेशन से आपने कॉन्ट्रैक्ट को क्रिएट किया, किसी और पर्टिकुलर म्यूचुअल एग्रीमेंट टर्म्स पे आप उस कॉन्ट्रैक्ट से डिस्चार्ज हो सकते हो. एंड दिस म्यूचुअल एग्रीमेंट कैन बी in one of the four ways, where one of the party, even if accepting less, can forego his right and discharge the other party from his obligations under the contract, and that is why we say that it is a form of remission. So voluntarily, one of the parties has waived off the right and discharged the other party, and therefore contract stands discharged by the concept of remission, which is by mutual agreement. Similarly, you may have entered into two contracts with the same, or that those similar contracts are entered between the similar parties, or it can also be a case that you created a contract between party A and party B, and they entered into a contract again, and that second contract was in scope broader than the first one. So there was no need to carry on the original contract as all its conditions has already been covered in the second broader contract. So therefore, these two contracts may be merged so that we don't have to carry the burden of two separate contracts to discharge. So by the merger, so as has been written, when an inferior right is merged into a superior right. फॉर एग्जाम्पल एक एग्जाम्पल आप नोट यहाँ लिखा हुआ है कि ओनर ने टेनेंट को प्रॉपर्टी रेंट आउट करी और फ्यूचर में टेनेंट ने ही प्रॉपर्टी खरीद ली. नाउ दे बिकम द बायर एंड द सेलर. So once this new contract is entered into, the old contract expires because the right to stay of the tenant has now become his right to stay because he has become the owner of the property. So this original contract stands discharged because its right has been merged into the new contract, and that is what we use by the word merger. So that is why merger is a mutual merger is, I can say, is a mutual way of discharging liabilities from the own contract. Similarly, alteration. When you created the contract, you agreed on certain terms, but with the period of time, you realized that these terms need to be varied for a better contract performance, and therefore both the parties with their mutual consent agree to alter any or all the terms of the original contract, and therefore after this alteration the new contract will come into enforce, and therefore old terms were discharged of. Similarly, we have this word innovation, where we are not merging, but what we are doing that we have replaced the old contract. So alteration and novation they looks more like same, but the difference being that in alteration you are changing the few clauses of the old contract and not the contract wholeheartedly. But in the novation, you just not change certain alterations, certain clauses, but you change the whole contract. So sometimes it happens that if you change a few clauses, then the basic essence of the contract will change, and hence, instead of going for the alteration, the parties go for the novation, where they replace the old contract with the new contract so that there is no confusion in the performance of the contract. So in this way, parties on mutual terms agree and discharge from their obligations under the old contract or the old clauses. Then the fifth case of discharge is one of the most logical one, that what they entered into at the time of contract has been fully worked for. That is A और B जो ऑफर और एक्सेप्टर थे उन्होंने जिस बेसिस पे कॉन्ट्रैक्ट स्टार्ट किया था दोनों ने अपनी अपनी ऑब्लिगेशन पूरी कर दी. So what A wanted from B has been received, and what B wanted from A has been received by B, and therefore both has fulfilled their obligations and provided considerations as required to be paid under the said contract. So we say that the both parties stands discharged from such contract because of the complete performance of this contract, and that is what we created the contract. So performance is the reason for which the contract was created, and that is why once it is done, the contract stands discharged, and now the party are free to create fresh contracts on the matter. Then we have this word supervening impossibility. That is, you entered into a contract and then you realize that this contract will not be able to be achieved. So there is certain impossibility which has, yeah, which was not prevalent at the time of entering into the contract, but now it is entered into the performance of the contract, or we can say that now the parties believe that this contract will not be able to be performed, and that is not within the control of the parties of the contract. So there is certainly supervening a possibility that denotes something which can never be completed even after the best efforts of the party, and therefore Such supervening impossibility forces the contract to be discharged. For example, अगर आपने मैच की टिकट खरीदी है तो आप एक तरह से लीगल कॉन्ट्रेक्चुअल ऑब्लिगेशन में एंटर हुए. यू हैव द राइट टू वॉच द मैच, बट if the rain or the continuous rain spoils the match, and it is not possible that even after 2 3 days the rain is not stopping and therefore the match has been called off. So it was a supervening impossibility. I'm not saying that you will not be entitled to refund, but you cannot enforce the performance of the contract that the match should be played because you purchased a ticket for watching the match, because there was a supervening impossibility and this was not beyond the control of anyone, and therefore the party stands discharged from such contract. And after these six options, we come to the most important one, where we use the word breach of the contract, and that was the focus of the session. Breach denotes that willful default. So when the parties entered into a contract, they committed to provide the consideration as agreed. And if they fails to fulfill such promise, if they fail to fulfill or provide such consideration to the promisee, then they are deemed to have committed the breach of the contract. And this breach can either be actual breach or the anticipatory breach. The difference between the two be only that when this failure of performance is done at the time when it was due, then it should be known as the actual breach. But if it is fully anticipated and sure that the time of performance is coming in the future, but the present circumstances clearly justifies that there will be a breach in the future and that cannot be undone. So that is why we say that the breach has been anticipated before the due date of the performance and that can never be avoided. That is, the breach is for certain. So we use the word anticipatory breach. तो एक छोटा सा एग्जाम्पल है, दो मैरिज इज नॉट अ कॉन्ट्रैक्ट, बट स्टिल एक एग्जाम्पल के लिए समझने के लिए कॉन्सेप्ट को कि भाई अगर लड़की लड़की के बीच में एग्रीमेंट हुआ है कि वो शादी करेंगे और शादी के टाइम पर लड़का या लड़की कोई नहीं प्रेजेंट हुआ तो एक्चुअल ब्रीच है. लेकिन अगर किसी की शादी 2 दिन के बाद है और आज लड़की ने शादी किसी और से कर ली, तो वो 2 दिन के बाद की शादी हो ही नहीं पाएगी, और या होगी तो इलीगल होगी क्योंकि उसकी शादी तो आज किसी की हो गई एंड सेकंड मैरिज इज नॉट अलाउड. So it is obviously anticipatory breach that after 2 days, what was to be done is not will not be done, and the other person जो दूल्हा है वो वेट नहीं करेगा कि भाई एक्चुअल शादी में आएगी नहीं आएगी, क्योंकि अब वो आए ना आए शादी तो पॉसिबल है ही नहीं. So it's a kind of sure case where the breach has been performed and it has been anticipated even before the due date of performance came into existence. So, irrespective of the fact whether it's an actual breach or the anticipatory breach, but the party who defaults on his performance must be under an obligation towards the aggrieved party. So, here we will use the word aggrieved party. What I'm saying, the word aggrieved party, aggrieved, and we will have this word defaulting party. So, the person who has undertaken the breach of the contract is the defaulting party, and the party who is suffering the consequences will be the aggrieved party. And this breach of contract gives certain remedies to this aggrieved party to enforce against such a defaulting party. So, what are the remedies available to the aggrieved party against the defaulting party is as follows. So the first has to be the specific performance that now whatever remedies we are discussing, it is not possible that the all remedies will be available in all the cases. It is possible that some remedies will be available in some cases and others will not be applicable. For example, if I just gave this example of marriage, तो अगर शादी हो गई तो आप स्पेसिफिक परफॉर्मेंस को एनफोर्स नहीं कर सकते क्योंकि अब तो शादी हो चुकी. अब वो शादी अगर तोड़ भी दोगे, स्टिल यू विल नॉट गेट व्हाट यू वांटेड. सो in certain cases the specific performance is not possible, in certain cases specific performance is required. So primarily where the contractual obligation is purely of personal nature, then we can always ask for the specific performance. So we always say that sometimes the aggrieved party may insist that the defaulter be made to perform or made to fulfill his obligation which he has agreed into under the contract. So the party says that we are not ready to accept any other thing, the apologies, the damages, etc. Instead, we want that person to not breach, and we, if the breach has not happened, then we can stop such breach, and if the breach has been done, then we can decide another ways of fulfilling those contracts. For example, अगर एक बिल्डर से आपने फ्लैट खरीदा जिसमें कमिटमेंट थी कि वो इस पर्टिकुलर डेट पर आपको फ्लैट प्रोवाइड करेगा और he has failed the builder has failed to provide the flat as per the conditions, as per the terms, or as per the dates, then either the aggrieved buyer can go for the damages, or they can specifically force that you enforce the builder to provide the flat, the property as he agreed upon. So it is possible that the aggrieved buyer presses for the specific performance and wants to buy the exact house as was promised. So ideally, such specific performance is required when either the aggrieved party believes that if he is given any damages, then those damages will not be adequate, or whatever the damages are, they will not be sufficient because it is not properly possible to anticipate the losses, and therefore he stresses on the specific performance. Similarly, we can have that the contract or the agreed party stays for the injunction. So this primarily focuses on that when there is a anticipatory breach, then instead of waiting for the breach and to claim for other remedies, you can always move in to stop this anticipatory breach. So when you stop a party to go for the breach, then we say injunction or the temporary stay order. So basically, it is a kind of discretionary remedy where the party is stopped from performing the breach, or where there are chances that the breach can be there, so the court may order that such breach should not happen. Similarly, we have this word rescission, which basically supports the tit for the tat action, where कि अगर defaulting party ने breach किया, the aggrieved party कहते हैं भाई अगर if you don't need our services, then we don't need your services, so get lost. रेसिशन मतलब कॉन्ट्रैक्ट को तोड़ो, आप अपने घर बैठो, हम अपने घर बैठेंगे. So it is possible in the cases where the contract is voidable, because they are such contracts which can be voided at the option of one of the parties. So if one party defaults, then other party can always go for the rescission, or the contract has become unlawful. So because of any change in the law, if when you created the contract, then it was legal, and therefore, or maybe after some time, because of the change in the law, if the contract has become unlawful, then we can go for the rescission, that is the break of the contract. Then the fourth option is the quantum merit, which denotes as much as earned. It says that whatever the remedies the court will justify, but if the contract is in a continuous stage where one of the parties have provided some part of its consideration to the other party and there is a default from any other party, then whatever amount has been earned by such aggrieved party, then he is liable to say कि जितना आपने मेरे से benefit लिया है, that benefit must be returned to me. So if defaulting party has enjoyed certain benefits of consideration from the aggrieved party, and now there is a default, then aggrieved party will always say that first give me whatever you have taken from me, you just get it back, and then you decide the further course of action. तो जैसे हमने एग्जांपल दिया कि अगर जिस लड़के लड़की में शादी होनी थी, लड़की ने 2 दिन पहले ही शादी कर ली किसी और से, तो अदर पार्टी कैन से कि जो आपने मेरे से बेनिफिट लिए हैं, कुछ ज्वेलरी, कुछ और गिफ्ट जो आपने दिए हुए हैं, वो तो वापस करो. वो वापस करने के बाद फिर सोचेंगे कि आपके खिलाफ क्या लीगल एक्शन लेना है. सो एज मच एज अर्न इज हैज टू बी रिटर्न. दैट व्हाट द मीनिंग ऑफ द वर्ड क्वांटम मैरिट. एंड देन द फिफ्थ ऑप्शन, which is the basic essence of this contract act being a civil law, Because the primary difference between a civil law and the criminal law is that in criminal cases, you don't settle for the damages, still you look for the punishment. So the state is not ready to settle for damages and primarily looking for the punishment. Whereas the law which are of civil nature are primarily meant because they believe that the default or the breaches can be settled from the financial losses, or default of one party is causing financial damages to the other party which shall be compensated instead of going for the punishment, and that is what the basic essence of civil law is all about. So therefore, whatever the aggrieved party is liable to pay, whatever the defaulting party is liable to pay to the aggrieved party is what will justify the loss of such aggrieved party because of the breach undertaken by the defaulting party, and that what denotes the damages. And these damages can be of various types: ordinary damages, special damages, vindicative damages, nominal damages, and the liquidity damages. And we just should stress upon the last three, that if we stress upon the vindicative damages, then these are such damages which are basically punitive in nature. So here, the loss of the aggrieved party is primarily mental. He has suffered the mental loss, the depression, and therefore, or maybe the loss of the goodwill, and therefore there are extraordinary situations, and these extraordinary situations will require exemplary damages. So where there are extraordinary situations which have caused huge mental losses to the aggrieved party, then then we go for the vindicative damages, and they have a special law कि जितनी छोटी गलती है शायद उसके कारण गुडविल का लॉस बहुत ज्यादा है। तो जैसे हम लोग शादी का एग्जाम्पल लेकर चल रहे हैं बार बार, तो अगर ब्रीच इसलिए हुआ कि पहले तो आपने शादी एक्सेप्ट कर ली और बाद में आपने कहा कि नहीं, आपके बाल छोटे हैं, आपका कलर ऐसा है, आपके फीचर्स ऐसे हैं, एक छोटी पैटी सी बात पर आपने डिफॉल्ट करा, तो उस छोटी सी बात से जो लॉस ऑफ गुडविल है, जो मेंटल स्ट्रेस है, वो बहुत बड़ा हो जाएगा। एज दे से कि अगर आपने किसी बैंक का चेक किसी को इशू करा और आपके बैंक में बैलेंस होने के बावजूद भी चेक बाउंस हो गया, तो इट इज द फॉल्ट ऑफ द बैंक दैट दे हैव रॉन्गली डिसऑनर्ड द चेक। सो एदे से कि बड़ा चेक तो डिफॉल्ट होना पॉसिबल है, लेकिन अगर किसी ने छोटा चेक बाउंस कर दिया, तो ही विल हैव द ग्रेटर लॉस ऑफ गुडविल बिकॉज द अदर पार्टी विल से अरे, 200 रुपए का चेक भी बाउंस हो गया आपका, आपका तो बिल्कुल ही हालत खराब है। सो वी से इन द केस ऑफ दीज vindicative damages like the dishonor of the check, or I should say the wrongful dishonor of the check, that smaller the amount of the check dishonored, more will be the damages that will be paid, or that shall be paid, or that will be forced on the bank to pay for the loss of goodwill to such aggrieved party. Similarly, there are certain penal damages where the primary focus is to punish the defaulting party for the breach committed, and therefore we take liquidated damages or the penalty damages, and therefore various kind of damages are also charged. So it is not like that all these remedies will together be applied for, and nor it is possible we can say that only one of them will be applied for. It depends upon the merits of the case, the judgment of the court, that which kind of damages to what extent will be levied on the defaulting party as per the gravity of the case and the nature of the default.